Content warning. This episode contains discussion of child sexual abuse materials, murder, rape, and violence.
Today on the Murder Sheet, we're going to be doing things a little differently. We're going to be introducing a new type of episode to you all. We're calling it the Cheat Sheet. This is sort of like a chat episode where we just talk about a number of different issues in true crime that we're following. We'll talk about some cases that we've been following, updates, chat about what's happened in those cases, and give you our takes on certain things. We'll still be maintaining somewhat of a formal tone as we're talking about pretty serious issues, but it will be an opportunity for Kevin and I to be a bit looser in our conversation and go back and forth with different things. It's also a way for us to be a little bit more on top of some of the breaking news alerts and some of the developments in these cases. So bear with us, and we hope you like the cheat sheet. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is the Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're the Murder Sheet.
And this is the Cheat Sheet, Summer 2023 updates. I actually wanted to check back in with a case that we did that was has had a pretty major break in it recently that we happened to cover before said break, but had nothing to do with said break. And that, of course, is the 1975 abduction and murder of Laurel Jean Mitchell in North Webster. We've been sort of monitoring that case in the background, and there are some updates in the case that I wanted to talk with you about, Kevin, that I thought were somewhat interesting. So, of course, Fred Bandy and John Wayne Lehman are the two suspects in that case. They have been charged with her murder. In Bandy's case, all we've seen on my case is just in March, the state asked for more time to comply with discovery, and the defense asked for more time for an omnibus hearing and pretrial conference, which has been since pushed back to October 30th, 2023. The justice system is not fast. But there's a wrinkle in John Wayne Lehman's case that I wanted to single out here in this episode. It started with one filing actually from Max Weber, who is the sheriff of Noble County.
The Noble County Sheriff's Department has found pretrial inmate John W. Lehman a safety risk to the Noble County Jail, pursuant to Indiana Code 35-33-11-11. He will become a safety risk effective July 31st, 2023, when he is transferred to this facility from Lutheran Rehabilitation Hospital. Mr. Lehman will require 2 officers to move him from his bed into a wheelchair and/or bedside commode. He will also require to be housed in a cell by himself due to the medical equipment needed for his recovery. This equipment poses a potential danger to others. Our average daily population over the last year is 225 inmates. The facility is operated at a minimum of 4 officers on duty at a time. The Noble County Jail facility officer to inmate ratio is not capable of maintaining the safety of the other inmates and staff while also providing Mr. Lehman with the level of care needed for his recovery. We are petitioning the court to find John W. Lehman a substantial threat to the safety of others in the Noble County Jail and order he be transferred by the Noble County Jail to a facility designated by the Indiana Department of Corrections for suitable housing. Respectfully, Max C. Weber, Sheriff, Noble County Sheriff's Department.
Kevin, what do you think about that? That this sheriff is essentially saying, this guy is a danger to others, not because he's necessarily inherently violent, he's a very old man, but because he requires all this medical equipment that other inmates could use to hurt themselves or others.
Yeah, it's very interesting, this situation, because also it kind of echoes what we've been hearing in Delphi, where Richard Allen is alleged by the state to not be able to be properly housed in a county facility. So we're hearing the same sort of thing. Of course, it's different reasons here now.
Yeah, when you're dealing with a small county jail that has about, 200 beds, which I'll note is many, many times what Carroll County has, which I think has 30 beds about, it becomes basically like, if we feel overtaxed dealing with that, what's going to happen when you have this elderly person who needs his own space, he needs all this. So we're seeing once again a sheriff's office falling on the mercy of the Indiana Department of Corrections to relieve the issue. Although in this case, I will note, it did not work out for them because future filings came out to this. On July 24th of this year, Diana Heuermann, the program coordinator for the Indiana Department of Corrections, and Lieutenant Jennifer Cummins had an exchange. And of course, Cummins is the jail commander of the Noble County Jail. There was a back and forth email that was included to the My Case filings. Cummins wrote, "Is the DOC response to the acceptance of John Lehman a no?" Heuermann replied, "Correct, does not meet criteria." So they're not taking him. IDOC is not taking him. I apologize in advance to Diana Heuermann, whose name I very likely pronounced completely wrong.
One thing that people in the true crime community tend to do, certainly I think we've been guilty of this, is we think primarily of trials and such things like that is stuff that happens in the courtroom. But there's all sorts of supporting stuff that needs to be done and handled. And the most basic of which is the defendants need to be housed. And if they have medical conditions, those need to be attended to. And if there are people like a Richard Allen who might be at risk in a conventional jail setting, that also has to be attended to. There's all of these pragmatic things going on behind the scenes that the sheriffs and other people have to deal with that I think a lot of the times we don't really think about.
One thing that helps me is that when I was reporting on retail, you go into a Costco, you go into a Walmart, you go into a Target, you're seeing that purely from the consumer experience. Was the line too long? Were there not enough cashiers? Did they not have the product I wanted? But you have to remember that for people who work there, it's a job. There might be some story behind, oh, well, they're not hiring enough people to be cashiers. That's why no employees are up there. It's not because the employees are lazy. It's just that one of these retailers maybe is basically cutting back on staffing budgets, and that's trickling down to the stores. Or perhaps that they severed a relationship with a supplier, that's why they don't have that product that you wanted. There's a story behind everything. It just kind of goes back to, unless you're working in that field or unless you've really done a lot of digging in that field, you just don't know what you don't know. There are unknown unknowns.
Quoting Donald Rumsfeld.
Yeah. So I think when we're talking about true crime, and again, you and I have been guilty of this for sure, it's really important to keep an open mind and remember that there's all sorts of weird machinations on all sides going on that are either not being scrutinized at all or are under scrutinized or people are not understanding. And that's why we always really appreciate our audience being so friggin' smart, and also like having so many professionals who reach out to us and talk us through some of these things, because it helps us understand better, and also not jump to conclusions. Like, you don't want to jump to, oh, they're trying to do this, or it's a conspiracy, or the defense is being awful here. No, oftentimes there's perfectly good reason, a perfectly boring reason that stuff is happening. And we can talk about that. And it doesn't necessarily make a situation good or bad or anything. It just maybe adds more context to explain said situation.
We assume that, if we ask a sheriff or a facility to do X or Y, then of course they do it because they have to and it's part of their job, and we imagine they have the resources. But think about how you would feel if someone came into where you work and started giving you difficult or challenging assignments that were out of your customary experience. So let's just try to be understanding of the behind the scenes workers and all that.
Or there might be specific criteria that one side feels is being met, the other side doesn't agree. It's complicated. Life is so complicated.
And of course, it's also incredibly important to protect the rights of the defendants at all times.
Yeah.
So there's a complicated dance of competing interests in everything in this.
And one thing that we're seeing, in the Noble County Sheriff's Department, they're citing, hey, we're going to have to put 2 officers on this. And, with Carroll County, there was a lot of talk, and we'll get more into that later because we're going to talk about Delphi today. But there was talk about we don't have enough people in hiring. One thing that we've seen rumblings of and, have gotten the sense of that there is some sort of law enforcement hiring shortage going on in Indiana, if not nationwide. So that's a kind of macroeconomic look at something that may be affecting some of what we're seeing here. If different agencies are not able to hire enough people to do the work, then what sort of difficulties arise in the criminal justice system? From what I understand, the next hearing in Lehman's case is for August 28th of this year. And the next hearing, as I mentioned, for Bandy's case is for October 30th of this year. All that's subject to change. Oftentimes things get delayed, but we're definitely thinking about Laurel Mitchell and the people of North Webster and hope to do some future episodes on that with some interesting folks that we've talked to about their connections to the case. Now let's move away from Indiana and get into Idaho for a minute. First of all, some housekeeping. We want to apologize for mispronouncing SNPs. We were calling them SNPS or something, but it's SNPs. A wonderful source who we have corrected us on that. Thank you to them. And one thing that the press around Idaho has been running with is the angle on Kohberger, basically Kohberger's defense accusing like a dirty cop of planting his DNA. And we actually covered the DNA angle a little while ago in one of our previous University of Idaho murders episodes. But I thought that was interesting. I don't think I really emphasized that enough in that episode. I don't know if we picked up on the extent of that. So that's interesting. I tend to think that that's a bit of a last resort when you're relying on like the cops planted the evidence as a defense.
I would be curious as to how exactly they planted Kohberger's DNA. And I would also be curious as to how they allegedly chose Kohberger as the person whose DNA they planted, and how they would know for sure if Kohberger would have his whereabouts unknown at that particular time so they could frame him. Yeah. There seemed to be an awful lot. It seems like it would be really hard for police officers to frame a person. And I imagine if they did, they would have to have a reason to target this particular person.
To the point also where they're willing to risk like their careers and freedom, because that would be a crime in and of itself.
Yeah, if you frame a person for a capital crime, that's a pretty serious thing to do. There'd be consequences for that.
I mean, I'm not saying it's never happened. I'm not saying it can't happen. I'm just saying that I think you and I are pretty skeptical of that line of defense because it seems to be like the last resort, in my opinion. That being said, we're open-minded and would be interested to see. It's also possible that what they're alluding to here sort of got boiled down in the most kind of broad way by press, and that it was more of a situation where they're saying, we think the police messed this up and there was cross-contamination or something bad happened. And it's not necessarily that we're saying that there's a vast Idaho conspiracy on this situation.
Yes.
So we're open-minded but skeptical.
Yeah, we're both familiar with cases with all sorts of crazy things that have happened.
Yeah.
But I
guess it's like when it's an unconventional and frankly far-fetched explanation, I like to see a lot of evidence pointing to it. That makes me say, okay, yeah, that was a crazy situation, but guess what? There's a lot of evidence that it happened. So there you go.
And of course, if you're a defense attorney and there's a lot of evidence pointing to your client, pretty much your only option is to try to find some way to discredit that evidence. Maybe you could say, well, this is just a tiny piece of the evidentiary picture. Other pieces of the puzzle would make this evidence look different. Or another thing you can do is say this evidence is simply wrong. And that seems to be what they're trying to do here.
To quote Seal, we're never going to survive unless we get a little crazy. That's what I see it as. It's like, this is the only thing we can do, so we have to do it. And that's a defense attorney's job.
Yes.
Not criticizing that, but I think sometimes people take that a little bit too seriously.
Do we know who Seal is?
I do.
Okay, that's good enough.
Pop star of the 90s. And his name is also a legal term. So there's also a bit of back and forth between the state and the defense, specifically J. Weston Logson, one of Brian Kohberger's attorneys, basically arguing over staying time for a speedy trial. There's like back and forth about, what date this is going to occur, and there's some squabbling over that. I don't really find that particularly interesting. But we also have some discussion of Kohberger's alibi. So essentially, my understanding is that there's some sort of like timeline where he has to give an indication of what his alibi is and if he plans to have that be his defense.
Yeah, I'm certainly not an expert on Idaho criminal law, but generally speaking, we talk a lot about how a trial shouldn't be a game of like surprise. And so if he has an alibi, the prosecution should be made aware of it so they can investigate it and either find holes in it or perhaps decide, oh, this makes sense.
Yeah, sorry about that. Let's let him go. It's not Perry Mason. It's, as you said, it's not like a big plot twist at the end. It should be more boring than that. So here's what Kohberger is asking for with his alibi. Mr. Kohberger notes that Idaho Code 1951-9-4 preserves his constitutional right to silence as well as to testify on his own behalf. Mr. Kohberger stands firm on his constitutional right as well as the statutory recognition of that right. Noteworthy is that an alibi indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at the time. Mr. Kohberger's defense team continues investigating and preparing for his case. Evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state as well as calling expert witnesses.
Well, they're saying, well, you'll find out about the alibi in the due course of time. You'll find out about it when we cross-examine witnesses and such, and we don't need to tell you before that. That's their argument, for better or for worse. They're saying, Mr. Kohberger has the right to remain silent, and that includes remaining silent about his alibi. So
I don't think the state was too happy about that because they filed a response. Comes now the state of Idaho buying through the Latah County prosecuting attorney and respectfully moves the court for an order compelling the defense to comply in full with Idaho Code 1951-9 and ICR 12.1 and provide the state with a notice of any alibi that may be offered herein. Said notice to include 1. The specific place or places at which the defendant claims to have been at the time of the burglary or homicides in this case, and 2. The names and addresses of all witnesses upon whom the defendant intends to rely to establish such alibi. The state recognizes that the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense, State v. Juarez, Taylor v. Illinois. However, as noted in both these cited cases, the defendant's right to call witnesses in his or her defense is not unfettered, and the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. Given the time constraints, the state prays that the court direct the defendant to comply no later than 10 days from the date of the court's order, and that the state be allowed pursuant to Idaho Code 1951-9-2 to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses, and any other witnesses to be relied on to rebut testimony of any of the defendant's alibi witnesses no less than 10 days before trial. Alternatively, the state prays for an order of this court pursuant to Idaho Code 1951-9-4 prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. How did you interpret the situation about him not bringing his alibi already? Is that stalling? I mean, why not bring it forward at this point?
That's a good question. I think in most cases, a defendant would want to readily share his alibi because, in theory, if the police arrest you for robbing the Arby's that's down the road. And you know for a fact that at the time of the robbery, you were on YouTube doing a live for our Patreon. And there's plenty of evidence of that. You think as soon as the police would come to arrest you, if you have such a strong alibi, you would present it.
Yeah, you would think that would be a card you would play pretty early. I think the biggest thing that's happened in Idaho since we've last talked about it is that the defense has moved for the case to be dropped. And that is on the grounds that the grand jury that indicted Kohberger was incorrectly given information about the standard of evidence that needed to be met.
And of course, you often see defense attorneys asking for cases to be thrown out for one reason or the other. It's pretty common.
Maybe not every case, but it's very common. And
it's pretty common because what do you have to lose?
Can you explain?
And also, if you file a motion to dismiss, it's a way of preserving potential issues for a record down the road. So even if you think, well, this particular judge isn't going to respond to this argument, if there's an appeal somewhere down the road, you can say, hey, look, I tried to flag this issue. The judge would typically only throw out a case if the case is very, very weak. Because, of course, the judge is the ultimate arbiter of the law. And the jury gets to decide the facts. That means the jury listens to witnesses and decides what it thinks happens. And then the judge is the one that figures out how to apply the law.
So the judge would have to be basically almost sanctioning the prosecutor for what they felt was inappropriate charges, legally speaking.
Well, sanctioning is a bit of a strong word.
Okay.
But basically,
slapping on the wrist.
Basically saying this shouldn't have been brought.
So we would think that it would take a very weak case for that to happen. So in Idaho, this DNA evidence, this different evidence with the cars and whatnot, I think we would both be pretty surprised if...
I can't imagine the case against Kohberger being thrown out.
That doesn't mean it's necessarily like the judges on one side or the other. It's just in most cases, judges would probably not want to be put in a situation where they're throwing out a high-profile case. They'd rather leave that to the jury if they felt it was legally sound. It would take a very extraordinary turn of events to be to have a judge want to do that. It's a motion to dismiss indictment on grounds of error in grand jury instructions, or in the alternative, remand for preliminary hearing. This filing from Logsdon is fascinating to me as a history nerd. He goes into the history of the grand jury system starting in the medieval ages in England. And then we go into colonial America and the founding of Idaho. It's like an epic. I mean, it's sweeping. A lot of it seemed to me like, is all this detail necessary? But I was very intrigued by it, so I thought it was interesting reading. He's saying, this motion is made on the grounds that the grand jury was misled as to the standard of proof required for an indictment. 1. The Idaho Constitution, Article, Section, and IC 191107 set the standard of proof for grand jury at beyond reasonable doubt, based on the plain language of the statute. A. The legislative history of LC 191107 also supports beyond reasonable doubt standard. B. The Idaho Supreme Court cannot adjust the standard of proof as it is a substantive right. 2. The failure to properly instruct grand jury as to the standard of proof is grounds for dismissal of the indictment. A. The grand jury was erroneously instructed with the standard required for presentment. Thus, this court could treat the indictment as presentment. What on earth is presentment? Well, we got some interesting context from ABC. Presentment is a formal statement by the grand jury indicating to the court that a crime has been committed and that it's reasonable that the person committed the crime. The person named and said right. Presentment, this case being Brian Kohberger. And throw out this indictment or just make it a presentment, in which case we need to go back and actually have a preliminary hearing to make it stick.
Right.
This is a lot of legal wrangling.
And correct me if I'm wrong, but I believe at least at the moment, isn't this scheduled for trial in just a couple of months?
Mm-hmm. Yep.
So it seems like they have a lot of pretty big issues to hash out before the trial.
Yeah. So to be focusing on like legal technicalities is interesting.
Well, let's not say legal technicalities because anything in the law is important.
Spoken like a true lawyer.
I don't like the word technicalities because people have legal rights, and
fair.
It's not a technicalities. It's constitutional.
Duly noted. I'm no Idaho lawyer. If you are one, feel free to come on and yell at me. But
I'd love for that to happen.
Yeah, you'd love that.
We are so grateful to our wonderful sponsor, Brilliant Earth. Brilliant Earth is all about gorgeous, fine jewelry and a strong commitment to ethical business practices in the diamond industry.
As a married couple, Kevin and I understand how a special ring can serve as a token of love. And Brilliant Earth creates some of the most beautiful engagement rings and wedding bands out there to celebrate your unique love story. Check out their website and customize the ring that you and your partner will love forever. They have all sorts of wonderful styles, like elegant solitaires or free-spirited willows. But you can also completely customize your ring, imbuing it with your own personality.
No one wants to have their special wedding or engagement ring tainted by worries over unethical diamond sourcing. What really shines for us about Brilliant Earth is their commitment to ethical sourcing and sustainability. That level of focus is an absolute rarity in the jewelry business. It makes us feel like we're supporting a brand that really cares about making the world a better place.
Now, Brilliant Earth only works with beyond conflict-free diamonds. That means they exclusively work with partners who follow the strictest international labor, trade, and environmental standards. So you know that they are committed to ensuring safe working conditions and a spirit of sustainability.
Check out all of their beautiful pieces at brilliantearth.com. That's brilliantearth.com. This episode is brought to you by BetterHelp.
We're grateful for our wonderful sponsor, BetterHelp. Kevin and I are night owls, and we often take that to extremes. Even though we know getting plenty of rest is good for our minds and bodies, sometimes we have trouble settling down, and we'll end up staying up way too late as a result. Sometimes it feels like our restless minds are actively sabotaging us. We know what we have to do, but our brains are getting in their own way.
If you can relate to that, then consider this. Therapy can help us all learn positive coping skills, far more positive than staying up researching random stuff all night. Therapy can really help you figure stuff out, so your brain can work for you instead of against you. It helps you strive to become a better version of yourself.
We'd encourage any of our listeners thinking about trying out therapy to give BetterHelp a try. It's all online. Even if you're super busy, BetterHelp is totally convenient to your schedule. And it's easy to get started. Just fill out a quick questionnaire and get matched with a licensed therapist.
BetterHelp will help you find the best match, and you can switch therapists whenever you want for no additional charge.
Make your brain your friend with BetterHelp. Visit betterhelp.com/murdersheet today to get 10% off your first month. That's BetterHelp, HELP.com/murdersheet.
Experiences are what people love most about travel. With Viator, you can browse and book tours and activities so incredible you'll want to tell your friends. They offer everything from simple tours to extreme adventures and all the niche, interesting stuff in between. Viator has experiences in over 190 countries. There's something for everyone. Plus, Viator's travel experiences have millions of real traveler reviews, so you have the information you need to book the best activities for your trip. Viator lets you keep things flexible. Use Reserve Now and Pay Later to secure the activities you don't want to miss without being locked in. Whether you want to take a backstage tour of the Grand Ole Opry, a Miami Bimini Bahamas day trip by ferry, or a private guided tour of the Grand Canyon, Viator is for you. Download the Viator app now and use Viator 10 for 10% off your first booking. One app, over 300,000 experiences you'll remember. Do more with Viator.
Should we move on to the Long Island serial killer?
Absolutely. So one thing we've started covering recently is the Long Island serial killer. Of course, Rex Heuermann has been arrested and charged with 3 of the murders in that series. And there's been some interesting developments with his wife, Asa Ellerup, and she actually filed for divorce against him. This came in on July 19th, 2023. Writing for Fox News, Michael Ruiz got the exclusive report about the divorce. And there's actually some precedent here for a situation where a wife associated who was married to a man who turned out to be a serial killer got a very quick divorce. And in this case, of course, it's a bit different. Rex Heuermann has just been accused. He's constitutionally innocent. He has not been convicted of anything. But the previous case I'm talking about is of course, that of Dennis Rader, aka Bind, Torture, Kill, or BTK. He was a serial killer who was active in Wichita for years. He got arrested on February 25th, 2005 in one of the most just satisfyingly stupid moves a serial killer has perhaps ever made. What he did was so absolutely disgusting and heinous to his victims. It's just nice that, he obviously fancied himself this like criminal genius, and he basically got tricked by police into sending them, a floppy disk containing computer information that immediately identified him. So,
of course,
good job. But anyways, he had been married to a woman named Paula for 34 years. By all accounts, had no idea what he was doing while he, murdered 10 people between 74 and 91. He ended up in court confessing to all of these different crimes and describing in detail what he had done. So after that, but before his sentencing in July of that year, she filed for divorce. And actually the judge in that case agreed to waive the traditional 60-day waiting period. He gave her an immediate emergency divorce. I think we can all be understanding and empathetic for these people and who find themselves in that situation. Ellerup, for her part, actually has come out with a statement for media and for just kind of everyday civilians who are just kind of morbidly curious. Like, please don't be coming onto our block. Like, I'm paraphrasing here, but she basically said, like, this has disrupted so much of life in Massapequa Park on this street for their neighbors. People have kids, people have jobs, people have like dogs to walk. Can we all just back off a little bit? And I think Massapequa Park being so close to New York City just creates a situation where there's a huge, robust media market there. This is a national case. It has so much interest. Unfortunately, one of the byproducts of that is that you have disruption to people's lives when they find themselves near a case. And I think you and I, Kevin, can imagine if our quiet street suddenly was mobbed by news vans and people coming up to gawk near our neighbor's house, that would be pretty troubling and annoying.
It would be.
So I think we can be empathetic. And meanwhile, the other big things to report in that case is that news reports indicate that massive searches have gone on at his Massapequa Park residence on Long Island, but also in South Carolina. So here's a report from the Newsday team of John Asbury, Anthony M. DeStefano, Nicole Fuller, and Grant Parpin. They got a hold of a Chester, South Carolina warrant for July 14th for a dark green 2002 Chevrolet Avalanche. And of course, that's the vehicle that was cited in connection with the murder of Amber Costello. The FBI apparently has been digging into evidence of the murders at Heuermann's property in South Carolina, which is right next to that of his brother, Craig Heuermann, in Chester County. And they're looking for things like trophies, like phones, clothing, personal documents, ledgers, Bibles, personal effects, photos, recordings of victims, and then other implements that may have been used in the murder, including, bizarrely, Bounty Modern print collection paper towels. It seems like there's a lot going on there right now. So what have we been doing in the Delphi case recently, Kevin?
Well, the thing we did most recently was we just released another interview we did with Kegan Kline, where we released portions of that interview.
Yes, we didn't. Why didn't we release the whole thing?
There were things he said in the unedited version of the interview pertaining to specific people that we didn't feel comfortable reporting unless we were able to confirm it. with other sources, and there are also things that frankly seem to violate the privacy of other people. There was nothing we held back directly related to the murders, I believe.
Yes. And one thing people often ask us is things like, well, Keg and Klein, there's that water search. So that didn't have anything to do with Delphi, right? Or, what about, did he not tell police about the red Jeep? If we get word that any of our reporting is inaccurate, you will hear it. You will hear that here. So if we're not saying anything additional, then you can take it that is us standing by our reporting.
Yeah. So we are confident that Keg and Klein told the police the story about the red Jeep. We are confident that the river search was related to a story the police got from Keg and Klein.
Yes, it was Delphi related. That's it. I mean,
there's no question.
There's no question about that. And again, if we ever get to a point where any of our reports we feel were inaccurate, we don't have a problem coming on here and telling you that, because we want to give you accurate information and not bad information. If it turns out that in the past we gave you information that didn't pan out,
we'll come forward and say so.
Yes.
But those things we just said are not up for debate. That's what actually happened.
Just because they're not coming up at trial does not mean anything. It just means that they're not related to.
Yeah, in the sentencing hearing, it wasn't about what Keg and Klein may or may not have told police about Delphi. It was about what his communications were with these underage girls. So it just simply wasn't relevant.
The Delphi information does not have any real bearing other than the fact that he used the Anthony Schatz account, and the Anthony Schatz account was tied to Liberty German, but that's not going to come up in trial. That's not going to come up in his case, because he's not charged based on his communications with her. He's charged based on his communications with other underage girls. He's been sentenced. It's unclear what the future holds with him, but we're certainly still interested in getting information and reporting out that story, because on some level it's always going to be connected to Delphi, because it came up through the Delphi murders investigation.
Yes. Obviously the Richard Allen case is also connected.
Well, because
he actually was charged with the murders. It's unclear some of the stuff that's been going on there. We've been told that from now on nothing would be sealed, but there was this filing from an inmate recently that has been sealed, and the clerk of the Carroll County Court said they couldn't give it to us because it was confidential. And a member of Judge Gull's staff said, well, we don't understand why it should be confidential. But meanwhile, it hasn't been made available to us. It's
absolutely ridiculous, and they need to figure this out. Whether that means the attorneys should be filing seals properly, or whether that means that the clerk needs to figure out what their job is, I don't know. But it's frustrating, because it just turns into this telephone game, and this is just not how things should be. Things should be transparent. That being said, here's a question, Kevin. If attorneys file things under seal, do we have a problem with that? No, because that's the proper way of things being sealed. So if attorneys are purposely filing things under seal, that's great. Then they're keeping things private that perhaps should be private. Our only issue is that if there's no reason for a seal, or if there's no reason, if things are not sealed, then they should be made public. That's all. It's very simple. And I don't really know why it's continuing to confuse whoever it's confusing. We're not even casting blame. We have no idea where this issue is ultimately coming from. And we're just trying to figure out, how can we ensure that transparency is the order of the day here?
Exactly. The other big thing that's happened in Delphi recently is that Judge Gull issued her ruling on the defendant's request to be moved to another facility. She actually pretty strongly denied that. The evidence presented at the hearing on the defendant's motion to reconsider did not support many of the allegations advanced by defendant counsel. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility.
And she basically said it's reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury to himself for him to be in Department of Correction. That was a pretty severe, I will say, Nicholas McClellan, the prosecutor of Carroll County, did a pretty formidable job in that hearing, poking holes in some of what the defense was saying. I tend to be personally of the opinion that having somebody at the MCU at Westville is such a extreme step that I would feel more comfortable if perhaps, if not in Cass County Jail, that there was some sort of third party mental hospital situation going on. That might be what I would personally find the most comfortable, because then perhaps he can be closer to his attorneys but still monitored. But I thought there was some pretty devastating testimony from like Cass County Sheriff, who was essentially like indicating that his mental health resources were not as extensive as Westville. That sort of made it feel, and basically the idea that law enforcement was doing it as some sort of like conspiracy or something was pretty thoroughly debunked. And if he is suicidal, then, they have to really take pretty intensive steps to keep him from hurting himself prior to trial.
Exactly.
So I don't know. I tended to be on the defensive side with that. But at the same time, I thought I understand where the ruling is coming from, because a lot of it was like, to me, the central problem is he's not been convicted and he's at Westville. That's a big deal.
That's a very big deal.
So that tends to be my problem with it, fundamentally. Not that, the Carroll County Sheriff's Office was scheming to have him take... that is a small freaking department. And we're going to talk about that in a future episode. But that is a small department. And like, I don't think this was some malfeasance. And I think what Judge Scull is saying almost indicates that she felt that the claims were too big for what was actually proven. But, that being said.
I share your concerns. The idea of having a person who is legally considered innocent at Westville seems pretty harsh. I'm concerned about his access to his attorneys.
Yeah, I am concerned about his access to attorneys too. I mean, they should be, being able to really mount a robust defense here. It sounds like they're pretty far away from him. That being said, I think Westville is probably treating him better than most people on MCU. I mean, he's breaking his equipment. They're giving him more. And in addition to that, he is being closely monitored there. They indicated by prison staff at this point to prevent him from harming himself. So they obviously have vaster resources than that of Carroll County. It's a complicated issue. I can see both sides, I suppose. Just being a milquetoast moderate here, I guess. And so that concludes our discussion on the cheat sheet. Hopefully you found some of this interesting and appreciated getting some updates on some of the cases we've covered.
Let us know what you think, and if you think we should keep on using this format occasionally, or if you have a different point of view. But as always, thanks for listening. Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages.